Jason Murray is the Denver-based lawyer whose argument helped convince the Colorado Supreme Court that Trump should be disqualified from Colorado's ballot. Today, Mr. Murray made his Supreme Court debut, representing 6 Colorado voters who brought that initial challenge to Trump's eligibility. In addition to more than a decade as a trial lawyer, Mr. Murray has worked closely with 2 of the justices who are up there on the dais today. He clerked for Justice Neil Gorsuch when Justice Gorsuch sat on the 10th Circuit U.S. Court of Appeals. He also clerked for Justice Elena Kagan at the U.S. Supreme Court. Today, Mr. Murray appeared before those justices in a different capacity, making the case to them that the ruling he won in Colorado should stand, that Donald Trump should not be allowed on the Colorado ballot. Joining us now live after a very long, very stressful day is Jason Murray. Mr. Murray, congratulations on your appearance at the court today, and thanks for making time to be here tonight.
Thank you so much, and I appreciate you having me on.
So I know that this was not your first time in that courtroom, and you're very familiar with Supreme Court procedure, and you've seen a lot of lawyers step up to the podium today. How was it for you to do it for the first time?
Well, it was certainly a source of pride for me to get to argue in the Supreme Court for the first time, and also to be able to appear before my former bosses.
In terms of how things went today, I don't think it's going to come as a surprise to you for me to tell you that most observers think that the case is not going your way. Most observers think that President Trump will be allowed on the ballot, that Colorado's decision to take him off the ballot will effectively be overturned by this court. I have to ask if you share that common wisdom, if you feel like you have a sense of where the justices are going after what you went through in court today.
Well, I won't sugarcoat it. It certainly seemed like the justices were asking really difficult questions, mostly procedural questions about whether the states had the ability to enforce Section 3 of the 14th Amendment. I will say we got a lot of really difficult questions at the Colorado Supreme Court as well. And when the Colorado Supreme Court sat down to write their opinion, they realized we were right on the legal issues. So we hold out hope that as the court gets deeper into the legal issues here, they will realize that the law and the history is clearly on our side here. But certainly they did have hard questions today, and I don't think the court would decide a hard case like this one without asking hard questions.
Let me ask you to sort of go back into one of the questions on which I think you got some of the hardest questions. At least I'm not a lawyer, to a lay observer, and I think it's some of the journalism about what happened today. You've seen people reflect on what seemed like some very hard questions about whether or not Colorado as an individual state, or indeed any other state, should have a role that wouldn't directly, but would effectively remove a presidential candidate from consideration by the voters of the whole country. That issue, that prospect was raised a few different ways by the justices today, but I wonder if you just take it holistically and address that criticism of the take that the Colorado Supreme Court and your clients brought to the court today.
It's an important question, and I think it's based on a misunderstanding, because we weren't here today to ask the Supreme Court to allow Colorado to decide these issues for the nation. We were asking the U.S. Supreme Court to decide as a matter of constitutional law whether Donald Trump is eligible to be president, again, based on his own conduct of engaging in insurrection. That isn't a political question for a state to decide. That is a legal question for the court to decide. And although the case came up through a state court, many important cases of federal law, federal constitutional law, come up through state courts. But once they're at the U.S. Supreme Court, it is for this court to make the final decision that will govern for the whole country about the constitutional eligibility of the candidate. And that was the case we were trying to make today.
Hi, Jason. Ari Melber here. Congratulations to you and all the lawyers today, because it was a big case and a momentous one. On one of the most difficult things to do is handle that hot bench with 9 justices. So congratulations to all of you. 2 questions. I don't know if you want to answer both of them. But given what you went through today, and it's so hard and so like the whole thing is so fast and complex, is there any part where you'd want to do over or to extend your remarks or build on an answer? Because that can happen just in any part of life. So I'm curious if that happened all today and you'd share that with us. And then second, we discussed today on this panel, and it was clear in the courtroom, that there was bipartisan skepticism about one of your key points, which is that the insurrection was this unique and rare event. And I wonder, is there a way that through your argument, through the brief, which matters sometimes even more than oral argument, or through what you did today, that you could better sort of, to paraphrase a different legal standard, say, an insurrection is one where you know it when you see it. And we're not going to have a ton of frivolous, made-up insurrection claims if some bananas official in some bananas state says Biden did insurrection when he gave an interview, and you go, that was very different than the live TV documented insurrection that we lived through. You know it when you see it. So that's the question, do-over and that.
Absolutely. Well, let me take the first point first. I wouldn't characterize it as so much of a do-over as the fact that there were a lot of questions that were being asked where I'd get 10 words in before I'd get another question and wouldn't so much have a chance to respond. So one point I'd like to emphasize now, because it didn't come up so much at argument, is just how clear the evidence was and how lucid the Colorado Supreme Court's factual findings were on the fact that President Trump engaged in insurrection against the Constitution. This isn't some sort of secretive thing that relies on, dubious witness testimony. This was in plain sight for everybody to see. We saw the tweets. We saw his words. We saw his campaign manager the day of, his former campaign manager, call this a sitting president asking for a civil war. We saw that even after the Capitol came under violent attack and members of the mob were chanting, "Hang Mike Pence," President Trump poured more fuel on the fire on Twitter by painting a target on the back of Vice President Pence and egging the attacking mob on. And we saw his tweets at the end when he praised the attackers and justified their actions, saying, "These are the things that happen when an election is stolen." This case is as close to a virtual confession of intent to incite insurrection that you can possibly get. And so I thought that some of the discussion about, well, maybe one state will have one evidentiary record and another state will have another, didn't fully engage with that central point. And if you, I was going to ask you to remind me what your second question was, because now I've forgotten it.
Insurrection, do you know it when you see it?
I think it's more than that. The history is really clear on what an insurrection is. An insurrection is more than a protest gone wrong. An insurrection is more than a riot. An insurrection is a coordinated attack for the purpose of resisting execution of law by force. And Section 3 requires an insurrection against the Constitution. And that hasn't happened since the Civil War. Because here, an insurrection against the Constitution requires that you're attacking a function mandated by the Constitution, not just some ordinary law. And here we had an attack on Congress's constitutional duty to certify the presidential election results. So hypotheticals about the idea that a state might misuse Section 3 to go after their political opponents, I think just misses the point. I mean, you can always have frivolous applications of law, frivolous cases, that are factually and legally baseless. And we trust that our justice system will put an end to them by saying this is baseless. And I don't see why Section 3 should be any different.
Hi, Jason. It's Joy Reid. As a product of Denver Public Schools, I will congratulate you and the state of Colorado for making history by being in front of the Supreme Court. There was a point, and Justice Clarence Thomas, he didn't ask a lot of questions. He obviously asked the first questions as he's the senior justice. But there was one point that he was pretty animated with you, and there was some irony. I'll just say this for myself, that his wife, her relationship to the insurrection, I found quite ironic in listening to him speak. But there was a point at which he talked about the plethora of Confederates who were still around after the Civil War. There were any number of people who could continue to either run for state office or national office. So it would seem, he said, that would suggest that there would at least be a few examples of national candidates being disqualified if your reading is correct. There was a lot of engagement with you on that question of, if this is such an obvious point and Section 3 is self-executing, why aren't there other cases that we can cite where insurrectionists were disqualified in the way that you were arguing Donald Trump should be disqualified? So I would love for you to say more on that. If you could have a longer exchange, what more would you say?
One of the extraordinary things about this case is that we had about 50 professors of history who are the leading scholars in the Civil War and Reconstruction file briefs on our side in this case. And they explained that history. They said that immediately after the 14th Amendment was ratified, and even before, Congress was flooded by requests for amnesty from people who knew they would otherwise lose their jobs and be kicked out of office. The Union Army was evicting hundreds of people on a weekly basis from offices in the South that they were ineligible to hold. And we had a number of state court cases where state courts were determining eligibility under Section 3. I took it what Justice Thomas was asking was something much more narrow than that broad question, which is, were states ever trying to restrict federal officials from taking federal office? And the answer is no, but that's because of how ballots worked differently back then. States have the power to run elections and to control the ballots. That's incredibly clear from Article 2 of the Constitution. And the difference is that back then, states didn't write the ballots. They didn't run the ballots. Essentially, everyone was a write-in candidate. So the only way that a federal officer who was elected, like a member of Congress, would have their eligibility determined is after the election, when they came to Congress and said, I won, and then Congress decided whether to seat them. But that history just doesn't answer the question here, because now states are using that power to do ballot access determinations. And so then you have to ask, well, if states can exclude a person who's not a natural-born citizen or a person who's underage from the presidential ballot, which they've been doing for many decades, why can't they exclude an oath-breaking insurrectionist?
Jason Murray, the lawyer representing Colorado voters who sued to remove Trump from the state ballot, who won at the Colorado Supreme Court, defending that decision today at the United States Supreme Court. Sir, it was a heck of a big stage for your first time ever arguing for the Supreme Court. I know that there's pride that goes with it, but I hope you get some rest thereafter and that the adrenaline come down is not too painful.
Thank you so much. I appreciate that.
All right. Good luck.